Good day, everyone, and welcome back. We are now on day 2 of our Young AI PPI Members Summit. And for those who were able to join us yesterday, welcome back. And for those that are joining us today for the first time at our satellite session, welcome to our session. My name is Debbie, and I am the chair of the Young AI PPI Members Advisory Committee. And we're just really glad to have all of you join us here today, no matter where you're from. And I can see there are people from all across the world yet again on our Asia Pacific and Middle East satellite session. Before we officially start, and as people are making their way in, just taking an opportunity to share a couple of house rules with us. If you see the slide on the screen, this event will be recorded and will be made available on the YouTube channel, so you can go back to it or share the video with your colleagues and also contacts after the event. During the presentations, we appreciate it if you mute yourself. If you have questions, you can always submit them to the chat box or ask them later during the Q&A session after our panel concludes. If you have any technical problems, our events team are available. They are labeled as AIPPI events, so you can just chat with them directly if you've got any questions at all in relation to technical related stuff. And last but not least, some of the slides used today will be made available on request. If you would like to have a copy of any of the materials, please send an email to events@aippi.org. And now I'd like to pass the floor to our Vice Chair, Samantha Young, who will like to say a few words. Samantha, floor is yours.
Thank you. Thank you so much, Debbie. Thank you, everyone, for joining us. And on behalf of the Young AI PPI Members Advisory Committee, we would like to extend the warmest welcome to all of you for attending this third annual virtual Young AI PPI Members Summit. We're so happy that you can join us because we're in for a great program today in this Asia Middle East satellite session with amazing content by our Young AI PPI members for our own Young AI PPI members. So really a huge thank you to all of our speakers for you and your time, your contributions, and also a great content ahead. A special thank you we would like to extend is to the support from the AIPPI Bureau, the General Secretariat, and the events team, and of course, our Young AIPPI members, committee members, for all of your support and making this summit happen. So this year, we have a special feature of the summit, which is held across 2 days. Yesterday, we have successfully held the global session with 3 panels and 1 life skill session. And I'm sure some of you have joined us. And we're now very excited about this session on cross-border IP strategies in the digital age. We all know that how important it is for us to just really be aware of the strategies that we have, especially as we really develop in this digital time. So now, without further ado, we are so pleased to invite Mr. Fernando Becerril, Second Deputy Secretary General of AIPPI from the Bureau, to share his opening remarks with us. Thank you so much, Fernando. The floor is yours.
Thank you, Samantha, and thank you, all of you. Welcome to this 2024 Young AIPPI Members Summit. First of all, I would like to introduce myself. I'm Fernando Becerril. I'm Second Deputy Secretary General of AIPPI, as just Samantha said. And here, joining with me is Simon Wintervalk, who is Assistant Secretary General. And we're here today with you on behalf of the AIPPI Bureau to share with you this experience that we would like that you really enjoy. Yesterday, as just Samantha said, we had a global session which covered very interesting topics from the perspective of our professional practice. We talk about sustainability, plant varieties, and artificial intelligence, but also about soft skills, focus on the emotional well-being of people. That, by the way, we all really need this on these times, no? A very interesting program that today we will have is complemented with topics that will be discussed in this special session for the region. I know I know that in this event, there are, of course, young members of AIPPI, but also some other participants that are not members. Some of you are invited to this Young Members Summit by some friends or some colleagues, and I would like to invite you to know a little bit more about the organization. And if you find it valuable, to join, to get involved, and receive all the benefits of being an AIPPI member. And so I'm going to take a few moments to talk about what AIPPI is. AIPPI, as you may probably know, was created in 1897. So it's now 127 years old association. AIPPI is definitely the world's largest association dedicated to all aspects of IP. It is the only association without any geographical or professional restrictions. AIPPI has a balanced approach to the interests of all IP stakeholders. Diversity is valued and encouraged within the association. It has a truly global reach. We are above 8,000 members in 67 national and regional groups around the world, covering almost 100 countries. The members are individuals interested in IP protection. Anyone who has interest in IP can become a member. In our association, members are lawyers, litigators, patent attorneys, trademark agents, professors, judges, patent agents, scientists. Almost every profession involved in IP are members of the association. Now, talking about AIPPI, AIPPI's objective is, as our bylaw says, is to improve and promote the protection of intellectual property on both national and international basis. It pursues this objective by working for the development, expansion, and improvement of international and regional treaties and agreements and national laws relating to IP. AIPPI has developed a strategic plan focused on 5 strategic objectives for the period 2024-2026, which are broadening the range of discussion, harmonization and improvement of substantive IP laws, additional opportunities for a stronger voice, more interaction with members and IP community, and finally, new format events. As you can see, there is a very comprehensive vision of what we are building in our organization. And for all this to happen, we really need to be as diverse as inclusive as possible. For AIPPI, it is essential to listen all voices. Perhaps more than ever, the youth voice of our organization is fundamental to understand where we should focus our efforts. The world is in the course of change and evolution towards a new way of understanding each other, socializing, and of course, doing business. From the professional point of view, things are taking directions that we must understand, adapt, and put into practice in order to move in the right direction, both personally and organizationally. That is why it's very important for AIPPI to listen to the voices, ideas, and vision of the future from the new generations. Between all of us, people with experience and who had lived through challenging situations, as well as young people full of enthusiasm, creativity, and ideas, innovative ideas, we can build a new area for our organization. Stronger, more representative, and with a greater voice. This event, like this one that we are having today, with the active participation of this new blood of AIPPI, will allow us to build the AIPPI that we all want to see in the future. Please enjoy the next few hours in which you will have the opportunity to share great topics of interest to all, and above all, in which you will be able to express your point of view of these specific topics. Make this session a great experience for each and every one of you. May this Young Summit to be an event that you will remember for many years. Finally, I would like to thank you to the organizers. A great effort. Debbie, Samantha, Kevin, and all the members of the Young Members Advisory Committee. Our real appreciation for the hard work to make this event a real success. Please enjoy the session and let's discuss really important issues for all of us. Thank you.
Thank you so much, Fernando, for your great opening remarks. And thank you so much for joining us. And we'll now pass to our moderator and host of the session today, Mr. Kevin Feng. He's also from our Young AIPPI Members Advisory Committee. Kevin, over to you.
Thank you, Samantha. Hello, everyone, again. Welcome to this satellite session on Asia Pacific and Middle East focus of the 2024 Young AIPPI Members Summit today. I'm the moderator for this particular session. Again, my name is Kevin Fan from Taiwan's IP law firm. It's called Tsai, Lee & Chang. I'm a patent attorney with biotechnology background. I am a member of the Young AIPPI Advisory Committee. If you have any question, again, for short housekeeping purpose, if you have any question for the speaker, please add them to the chat box and indicate to whom the question is addressed to for the following three main topics. Without further ado, let's go into the first topic. Our first speaker is Mr. Arjo de Guzman. Arjo is a licensed Filipino lawyer. He leads the IP and litigation practice of the firm. As a leading IP practitioner, Arjo is a constant receiver of major IP awards. He's included in Asia IP Magazine's 2023 Philippine IP Experts, and it was cited for his excellent performance in trademark protections. Arjo holds a bachelor's law degree from the San Beda University and a master's degree in IP from the Jagiellonian University of Krakow, Poland. He's a constant member, active member in the various professional organizations, including AIPPI, INTA, and the IP Association of the Philippines. Arjo today is going to bring us about his insights on the IPs at the digital age. Now I hand it to Arjo.
Hi, good afternoon or good morning to everyone joining us today. And thank you, Kevin, for that gracious introduction. First of all, I would like to congratulate the organizers of this year's events. Again, Samantha and Debbie are with us right now. Fernando, congratulations for another successful summit. And for today, I will be discussing intellectual property in the digital landscape. Let me just share my screen. So it's a precursor to our general talk in the afternoon, because I will be discussing some common problems and gray areas in the digital landscape, which for some of us, especially IP lawyers, are new. Some of us are not so familiar with these particular key issues or key problems in the digital landscape. And of course, as we all know, there's no particular and unified rulings or issuances on these particular key aspects of that in the digital space. So let me just provide a brief introduction. If we are going to discuss the digital space right now, there are certain characteristics that we have to take note of. Number one, the rate by which innovation is evolving and improving is right now is described as exponential in nature. So everything is fast moving. Technology is outpacing the manner by which regulations and laws are being promulgated. Technology is outrunning the issues in terms of policies and governance. So again, it's exponential in nature. And being said that some of the industries right now are taking advantage of technology to disrupt certain traditional aspects or certain traditional industries which are already existent. Like, so in that sense, you also say that the digital technology or the digital landscape is very much disruptive. We can see a lot of good examples right now, which are not, like, for example, streaming platforms. There are a lot of a few good examples in fintech, which disrupts the like traditional technology industries that we have by utilizing technology. Of course, technology is ubiquitous. It's pretty much everywhere. So in our everyday lives, when you look right and left, when you go to the office, go to your school, or just merely by working on our daily routines, of course, there's technology to speak of. And being that the last two key characteristics of the digital landscape right now is it's very immersive and socially engaging. If you are going to talk about technology in the past, probably 20 years or 10 years before, it's not as socially engaging as it is today. Everyone, almost everyone has access to technology. Even the small children has access to technology within their fingertips or within their tablets by using their phones, their computers, and just connecting to the internet. So given that, it's very important for us to know how these different new technologies and innovations that are coming up in the market, in the industries, are interplaying or interacting with intellectual property, because one way or the another, we as lawyers, right, we as practitioners of IP should be concerned about what are the key issues to look for, what are the particular common problems that we should anticipate in order to do our job better. So with regards to IP, there have been a lot of like conflicts in the past. Some are highly visualized in different news reports. Some have been circling around the globe. There has been some craze about NFTs in the last couple of years, and then there has been right now the hot topic would be generative AI because of ChatGPT, Midjourney, and a lot of the applications that has been there in the market and has impressed users in the recent years. So given that, we have to, again, the stress of my talk right now is for us to pinpoint what are the possible key issues that we would encounter in the future. This is kind of a holistic talk, which and I would be very brief about this because, as I've said, there has been no real concrete decisions or rulings about these matters. But again, I would like to provide a particular overview so that everyone would be on the same page regarding these issues. So let us first identify key innovations that have been making the news in the past few years. Number one, we have the metaverse. One of the most common misconception about the metaverse is that it is existing at the moment. I hate to break it, but we don't have a 100% metaverse as of the moment because we don't have a digital space that is fully interoperable with different platforms. So when we talk about the metaverse, technically speaking, we're looking at a single world wherein each and every user can participate in and interact with each other. So there can be like the sale of virtual goods, the conduct of virtual business and activities. So that's the metaverse for us. Why is this important? Because we have to be aware of the fact that a lot of investments has been pouring into the goal of obtaining and into the direction of establishing the metaverse. Of course, if one particular instance and significant news in the recent years is the rebranding of Facebook into Meta. So that only signifies that Facebook is beefing up for its own iteration of the metaverse as it has been doing in the past few years. A lot of industries has also been pouring in substantial investments towards the metaverse. JP Morgan and Chase has been investing a lot in this, and a lot of industries or even financial industries has been considering this technology for now. Another is blockchain and digital cryptography. So blockchain is one of the things that is almost always been discussed with in connection with the metaverse because it is seen as a tool to realize the metaverse. That for me, the two intriguing characteristics of blockchain, mainly for one, is it's promising decentralization in a sense, although we have seen a lot of chains which are really not decentralized in nature. But that's one of the promises of blockchain, being decentralized in nature where no single entity are controlling the deployment or controlling whatever is governing inside the chain. Another thing is that, and I think this is the more important characteristic of blockchain or property of blockchain technology, is that it's immutable. So whenever you have something on the blockchain ledger, it's whenever something is recorded, you cannot change it. So that's where the value of blockchain is. And as you will observe in the different use cases for blockchain, the more prominent I think would be, and the more popular right now would be cryptocurrencies. But if you would go and if you would take a look at blockchain, there are a lot of real world use cases which have been utilized right now. It's just so that cryptos have been popular for the last couple of years because of the pandemic, I think, cryptos and NFTs. But if you would really take a look at blockchain, there's more to it than cryptocurrency. Next, as I mentioned, this is the hottest, I think, the hottest topic right now is generative AI, Gen AI, as we said, because of I remember last year I was discussing about NFT domains during the last summit, and yeah, and I don't know if some of you were able to join that particular breakout session. It's because a couple of months back, and particularly during the pandemic, NFTs were the craze. But then come the last quarter of 2022 when ChatGPT was introduced into the market, and then everybody's attention was diverted from blockchain and NFT into Gen AI. Suddenly, everyone wants to learn Gen AI. Every industry, every company wanted to learn how to leverage this technology, how to make their work and lives easier by using Gen AI. And another like interesting thing about Gen AI is that it's so pervasive. It does not focus on a particular industry. A lot of industries are using Gen AI right now. It could generate text. Also, some of the issues are in the creative landscape. Also, it could right now we're hearing and seeing news that Gen AI can be like used to generate even audio likeness of famous artists with artists. And so again, there are a lot of use cases, and really the capability of Gen AI is something we have not seen before. So again, it's one technology to look at right now. Now the last thing is big data, or which we call industrial or non-personal data. So when we talk about data in the digital and technological space, this is not something which relates to a particular identity of the person. It's different from data privacy issues. So what we're talking about when we say industrial and non-personal data here are the different data or information generated by large industries. Like for example, if we have a particular navigating app, or if you're using an AI implemented motor vehicle, all of the users there will be generating data based on whatever the producers of the machine would like to gather. So there's a big like question right now, even in terms of ownership, who owns this data? if you're hearing discussions right now, like for example, the most basic would be in streaming platforms. The streaming platforms would have useful data in terms of viewership, which particular region has the most viewership, what particular genre, what particular age bracket. So these data gathered from the multitude or the number of users are very useful data, but there are a lot of questions or issues, especially unanswered gray areas in industrial and non-personal data, which are lurking around and which we should be taking a notice of. And especially right now, the data has been noticeable in some of the cases because data has been used as part of the training models for some large language models in AI. So again, that's also the importance of non-personal and industrial data. So let's go to trademarks. As I mentioned, we will be focusing on like some gray areas and key issues. The most common right now issue in trademarks would be the question whether the virtual goods and services in the digital landscape could have an effect in the current setup of the trademark system. Like, for example, as I mentioned in the metaverse, users can like interact with each other, and it involves a lot of virtual goods being sold in the metaverse itself. So there are a lot of exchanges, there are a lot of transactions going on in this virtual and parallel world that they have right now. Now the question is, if you are an industry, and this is one of the questions that we could pose to our clients and to our colleagues, if we are going to dabble into the industry of having goods or our services offered in the virtual world, what would be the appropriate class for us to register our trademarks? So let's say, for example, you have a client of yours is like producing clothing under class 25, and they would want to participate in a particular virtual space project, and they would want to sell a reproduction of the shirts or clothing that they're selling in the real world into the virtual world. How do you protect that particular virtual good? Are you going to file a particular additional class for that? So that's one of the question. A lot of like discussion has been put forward. The most common would be taking the more conservative route of having them registered, or the application cover class 9 for virtual goods which are authenticated probably by NFTs, or goods which are being sold in the metaverse. So that's one of the discussion being put forward, but it could somehow be like expensive to some might have some different apprehensions involving that approach. Now, aside from the appropriate class in your application, another is could the use of virtual goods, or could the use of different services covered by trademarks have a new meaning and concept in terms of the metaverse or the virtual world? So is questions like, could this use in the virtual world be considered as proper use in terms of traditional objects or goods, or vice versa, whether these virtual goods used as objects in the virtual worlds could be used in reality? So this is another question. And of course, another in relation to the concept of use is their exhaustion. As we all know, when you buy something in the real world, like for example, if you buy a sneaker or a shoe, the protection to the trademark in terms of that particular item ends there, and the user can do whatever he wants with the shoe, whatever. However, there is another question: if we can really adopt the same policies or principles of exhaustion in the traditional world and adopt it and put it in the metaverse or the virtual space that we have right now. So these are some of the points. Now, one of the particular cases of interest is the recent case of the Meta Birkins case. I think most of us would know this. So what I would want to highlight on this case is that it's not really copyright, which is the subject matter of this case, but peculiarly the subject matter is trademark. So Hermes have a trademark registration for their Birkins bag, and of course, we all know that Hermes won this case, and then the court ruled that the production of the NFTs, which are really identical to the Birkins bags in the traditional world, infringes on Hermes like trademarks. So that's one of the case which has been decided recently, but again, it does not provide a definitive guidance in the interplay between NFTs and trademarks in the metaverse or in blockchain. What you have to point out in this case is that the NFTs are simply identical in matter. What the subject matter of this case are identical Birkins back. So the next question we would need to ask is if the ruling of the court in the United States would also apply if the issue concerns confusing similarity and not identical marks or identical goods. So again, these are some of the key points and probable issues that we need to address moving forward. Also, we have the issue of domain names. Last year, I was talking about NFT domains. Now, in terms of domain names, domain names have been there for quite some time. So I think we are more familiar with them than the metaverse or the virtual world. Again, one of the interesting cases is the case of Booking.com, wherein the trademark Booking.com was allowed in the United States. It was initially rejected by the USPTO, being one which is generic in nature. So the applicant argued there that the mark should be taken as a whole and not be segregated, like considering the words booking and .com as a separate parts of the mark. So in terms of domain names, so the question that we would want to answer and to take notice of is, are domain names confer the same protection as trademarks? Can we use domain names to protect your brands or trademarks? Or is it the other way around? Can trademarks be used to protect domain names? Some of these questions have been answered in some jurisdictions, but again, we might want to see, we might see some of changes within because although we have some decisions in this space, again, no particular principle is guiding at the moment. Of course, the question of infringement, so we may ask, does domain names infringe trademark rights? We have seen cases like this under the UDRP where domain names have been canceled because it is considered as infringing to TM rights. And what I've been mentioning a while ago, the NFT domains, these are new iterations of domain names which are really not trade domain names, but in the sense they are in the blockchain, which gives the particular address in the blockchain the easy readable marks. So let's go to the copyright, where most of the beefy issues are right now. So in terms of copyright, we have to take note of the basic of copyright protection. Again, that's originality, and that the copyrighted work has to have some representation, material representation. So again, the issue would be copyright. Is copyright enforceable in terms of virtual goods? So one of the oldest cases involving copyright in the digital space would be the cases regarding tattoo artists. Tattoo artists and these different producers of video games. So as you well know, sports personalities have tattoos in them, and suddenly these tattoo artists who ink these sports personalities started suing the video games containing containing the character's image wherein the tattoos and the designs are visible. So Solid Oak was the first one decided, and the other two cases, Alexander and Hayden, are still pending litigation right now. Of course, we have the Google Books project where the Authors Guild sued Google for its Google Book project. The Google Book project is a partnership of Google with different libraries around the world, in order to create like a database of the books available in the libraries and providing snippets for the users to check. Now, these are two images which are which are issued or created using generative AI. On the left side is Saria of Dawn, and the next on the right side is the Opera Space, or Theater di Opera Spatial. So these are two controversial works, including copyright and Gen AI, because number one, if we are going to go back, on the left, Saria was initially issued a copyright protection by the USPTO, but again, upon learning that it was some of the images therein, or the images therein were generated using Midjourney, it was the copyright protection or the post registration was recalled by the USPTO. And what was left was the copyright over the comic book and not over the images. The same decision was held in the image on the right. It was an image who won one of the prizes in Colorado, I think, in the United States, but was rejected copyright protection because it was generated using Gen AI app, which is again Midjourney. So what we have to point out in copyright is whether or the question of being protected, the work being protected, we should determine whether it is AI assisted or AI generated. So there lies the question. In some jurisdiction, they treat this more often with a similar nature. But again, the ruling of the USPTO is clear. If the image is generated using AI, Gen AI, the USPTO declines protection for those images. And another question would be, how about if the image are based on a particular image and not on a text, but not created on a text to image application? Could it be considered a derivative work or under the derivative right of the author or the creation or the creator? So that's another question we need to answer. Of course, issues on infringement, a lot of cases have been filed against OpenAI, ChatGPT, and a lot of Gen AI applications by a lot of complainants. But again, we have to derive and to identify where the infringement lies, wherein is the infringement going on in the input version of things, meaning to say the training models, the data that is used to train these AI machines, or are they does the infringement occurs in the output or what was generated? So of course, another question is whether the training data could be considered as a derivative work of all the data or the copyrighted works which are included and collated in the training data. Another question is whether there is a new definition for fair use. The fair use is mostly the defense which is mostly used by these Gen AI companies. So there's a question whether the output is transformative enough or not to constitute infringement or not. In terms of patent, and I have my last minute, I think I have to close my presentation right now. In terms of patent, what is more prevalent right now is the Daibus case. Of course, we are all aware that Taylor was successful in most of his applications except for one in South Africa. But we have to take note that South Africa there is no substantial examinations of patents, and that's why he got a patent award in South Africa. But mostly right now, the status is that the machine or the AI cannot be the inventor of a patent. That's at least right now, that's the consensus of its different patent office. But we have, again, I have listed these questions right now. And to close my talk, again, whenever AI is involved, it would change the landscape in patent, and it behooves to ask the question of obviousness: should there be a new definition of the state of the art in terms of patent? If we are going to allow AI as the inventor, or if we are going to allow AI assisted inventions to be protected, how do we define now the state of the art, considering the capability of these AI applications or machines at the moment? So with that, I would end my talk. And if you have questions, you can write it on the chat box. And I'm Argel from the Philippines. If you have questions in our jurisdiction, you can contact our law firm. You can contact me, and you can add me on LinkedIn. I usually post IP-related matters in LinkedIn, and I would love to connect with you all. So again, thank you very much. Have a pleasant day. I'll attend to your questions later on after the talk of the other speakers.
Thank you, Arjul. Thank you for this overarching survey of the interplay of the technology and all kinds of IP. About ownership of data that you mentioned inspired me that in Taiwan, comparatively within training of the AI models, it may involve the reproduction of data. And if they're protectable under the copyright law, the Taiwan IP office currently holds quite rather conservative view that some sort of a license or permission seems to be required from the owner. But it's not formed to a case yet, so we'll see and how it plays out in the end. Just a short share. The second speaker we have today is Ms. Shirley Wang. Shirley Wang is a patent attorney and attorney at law from the litigation department of CCPIT Patent and Trademark Office in China. As a litigator, Shirley has represented various companies like Chugai, Daiichi Saikyo, Alipay, etc., before the court, and as well as IP office in all kinds of cases. For example, patent infringement, invalidations, freedom to operate opinions, administrative actions, and unfair competition, etc. Shirley obtained her Bachelor of Science degree in biotechnology from the University of Science and Technology of China. She also holds a master's degree in science in bioengineering from the University of Illinois, Urbana-Champaign. Shirley is about to share with us the rules and practice of the patent linkage system in China. The floor is yours, Shirley.
Okay. Thank you, Kevin, for very comprehensive introduction. And also, I would like to thank the APPI for offering us this opportunity to share with our thoughts on some cross-border issues. Okay, and hello to everyone. And in the next 20 minutes, I'm gonna talk about some basic ideas and statistics of the new patent linkage system in China. Now I'm gonna share my screen. Okay. So in the next 20 minutes, I'm gonna talk with you about the basics and some new statistics of the patent linkage system in China, which is one of the most significant IP changes recently, and is clearly marked with the characteristics of this digital age. So actually, the history of patent linkage system can be traced back to 1984, the Hatch-Waxman Act in the US. And as you may know, the drugs are different from other ordinary goods in that a drug can only be sold on the market if it's approved by the drug office of the government. And such approval usually requires the clinical data of the drug, and so takes a lot of years to obtain. So as a result, the brand drug company, usually the patent holder, can only sue the generic drug for a patent infringement after the generic drug gets approved and hits the market. So which is probably like a lot of years after the the patent being granted and also the brand drug being hits the market. So the logic behind the patent linkage system is to link the patent holder and a generic drug company using the drug-related patents. And once the generic drug applying for approval, the corresponding patent holder will be notified and could file infringement suit to stop the generic drug from getting approved, and don't need to wait for the generic drug to hit the market. Okay, so that's the basic idea. And in those early days in US, the patent linkage was basically 2 books. It's literally printed out in hard copy books. As you can see here, the orange one was the list of the patents related with the approved chemical brand drugs. And the purple one is the patents related with biological products approved on market. So that was for the very old version of the patent linkage system. And in 2021, China has first time adopt the patent linkage system. And since now we're in the digital age, we don't need to print out hard copy books anymore, because we could just easily build up a searchable database for the patentee to list their patents and also for the generic company to search. So we call it a platform. You could see it's how it looks like here. And here are some types of patents which the patentee could list on that platform. And you can see it's basically fall into 3 big categories. The first one is for chemical drugs. The second one is biological products. And the third one is traditional Chinese medicine. And we call it TCM. And the TCM is really a unique thing for the patent linkage system in China compared to other countries. And under each big categories, you could have different types of patents. For example, for the chemical drugs, the listable patent types are compounds and compositions and also medical use. And it's quite similar for the traditional Chinese medicine. And also down here, you could see, so after the patent holder lists the patent, there will trigger a patent linkage system, but how the system works is actually different for chemicals and biologicals or TCM. We'll see this different flowcharts here. So this is actually for the chemical drugs. So we'll introduce it step by step. So first, it starts from the patent holder list the patents on that platform. As we said, it's basically 3 types of patents you could list. And then there is a time period, which is the patent holder has to finish the listing or the registration within 30 days after obtaining the market authorization. And then it comes to the generic company. So if the generic company would like to file an application for the market approval, there would be a table for the generic company to make one of the 4 types of patent certifications. So basically the first type is there is no patents listed in the system. So meaning the drug could go ahead with approval. And then the second is the patent. There is a patent listed there, but patent is lapsed, invalidated, or licensed to the generic company. And that would, this consequence of the second certificate would be similar to the first one. And the third is the generic company promised that they wouldn't market the generic drug until the patent is expired. Okay, so under that certification, the approval will just be postponed. And then the type 4 would be the patent listed in the platform should be invalid or is not infringed. So, and then the type 4 certification will be the most important one, because that will trigger a notification to the patentee. Okay, so the patentee will receive a sort of a statement from the generic company saying, okay, I have a generic drug. I think your patent is invalid, or I think my generic drug does not infringe your patent. And this notification will trigger a suit. So it's basically the patent holder has the choice to file a suit within 45 days after receiving the T4, the fourth category of the certificates. And the patentee has two choices here. So either he could file the infringement suit before a court, or he could choose to go to the National Patent Office, which we call it CNIPA. And if they choose the court route, it will be basically a civil case. And if it goes to the National Patent Office, it will basically an administrative adjudication. Okay, so two routes for them to choose. And then once they initiate the suit, the patent holder has to send a notification to the drug office, the NMPA, saying that, okay, I've already sued the generic drug company, so please wait. And the drug office will wait for 9 months. But during this 9 months, it's just the approval being postponed, but the technical review will continue. Okay, so then after the 9 months, whatever the decision from the national office or the court being issued or not, the NMPA will make their decision. So if there is a decision saying that the generic company wins, then the generic drug will be approved. And then if it says the innovator wins, meaning the generic drug fall within the protection scope of the patents, and then the approval has to be postponed until the patent's being invalidated or expired. Okay, and then the last step is in the case that if the generic company file an invalidation request against the patent in issue, and if the generic company wins that invalidation suit, and they will be the first successful patent challenger. And if they also be the first approved ANDA applicants, meaning their generic drug is the first one being approved by the NMPA, then they will obtain a 12-month market exclusivity. So meaning during that 12 months, there won't be any other generic drug being approved. So the market is shared only by this generic drug and the brand drug. Okay, so this is basically the chart flow of the chemical drugs. And here is how it looks for the biological products. It's a little bit different because it does not have the step 4. It's basically the waiting time, meaning the drug office, the NMPA, does not have to wait for the infringement suit being dealt with before the court or the CNIPA. So it means for the biological product, the patent holder could still file the suit, but then the drug office will not wait for the suit, the result of the suit. And accordingly, there won't be any market exclusivity for the generic drugs. And this will be the similar for the traditional Chinese medicine, TCMs. Okay, and I would say that the patent linkage system have largely shaped the whole landscape of the patent infringement litigation and also invalidation litigation. This is a whole picture of how it look like with the patent linkage system now. So the flowcharts we talked about in the previous 2 slides are actually this part. So the part outside of the red box. Okay, so it starts from the T4 certification and go all the way to the patentee file the infringement suit, either the civil route before a court or administrative route before the national office. And then the waiting time, which is 9 months for the drug office to wait. And then if there is a decision from the national office, or if there is an effective judgment from the court, the NMPA will take into consideration and then go ahead with approval. So here is the flow chart we just talked about. But in parallel, as we just said, the generic drug company will not just sit there and let the patentee sue them. They could sue back, right? They could initiate the invalidation request before the national patent office as well. And this line would be in parallel with the infringement. And the result of the invalidation would affect both the civil route or the administrative route or the ANPA decision, and also will affect if the generic drug company could get the market exclusivity. Okay. So yeah, so this will basically be how it looks like for the whole picture with the patent linkage system. And talking about the choice between the civil routes and the administrative routes. So how should patentee choose? There are some similarities and distinction between them. So first, they are very similar in these issues. So first of all, both of them can only be triggered by type 4 certification, which is either the patent is invalid or the patent is uninfringed. Okay, and within 45 days for the patentee to initiate the suit. And also the grounds are similar. Both the civil routes and the administrative routes will only deal with the question that if the generic drug fall within the protection scope of the patents. So they don't care about validity, and they don't care about damages or infringing activities. Okay, so it's only the establishment of the infringement. And then the parties. So if the suit is initiated by the patentee, it will be a patent infringement litigation. And if it's initiated by the generic company, it will be basically a declaration judgment of non-infringement. Okay, so it could be either way. And this is the difference between the civil and administrative adjudication. And I think this will be the key points the patentee should consider when they choose between. So first of all, the requirements of the legal documents are different. For the civil routes before the court, it's generally very high because you have to have all your legal documents notarized. So in these days, we don't require legalization, but notarization is still needed. But for the administrative routes, the POA or they're actually don't need other legal documents. It's only the POA, and the POA does not need to be notarized. So this will be very time saving. And also about what decision counts. So for if the patentee take the civil routes, it's going to be the effective judgment that really counts. Effective meaning if the opponent party appeal, you have to go all the way through the second instance. And for the administrative route, it's the National Patent Office decision itself counts. So this would be the key difference between these two routes, because this decision would usually be like 6 to 9 months, and the effective judgment would usually like 2 or 3 years. So they're big difference. Yeah, so the third was telling you how fast the decision would be. The effective judgment will usually unlikely to be issued in 9 months. And also the preliminary injunction. Theoretically, for the civil routes, the preliminary injunction is available, but in reality, because like we said, the drugs are different. They have to be approved by the government and then hits the market, right? And then for the preliminary injunction, it could only stop the selling activity or the offering for sale activity, but cannot stop the filing of ANDA, meaning by using the preliminary injunction, you cannot stop the generic drug being approved. Okay, so it's actually not that effective here. And for the administrative routes, there is no preliminary injunction. And then the relation between them. Okay, so if you have successfully filing of the administrative routes, this will not affect the proceeding before the court. But in the opposite, if you have successfully filing a civil action, this will lead to the dismiss of your administrative case. So if the patentee would like to take both routes or choose between, I think these are the key points for them to think about. And if the patentee want to take both routes, I would suggest them to go the administrative routes first, because if you do that later, it's going to be dismissed. Okay, and here are some statistics recently from, it's from last year, actually. It's the percentage of the patent certification. And as you could see, most of the certificates is more than 80% saying there is no patents listed. And for the type 4, which is either the patent is invalid or not infringed, most of the type 4 goes to invalid. So I think these would followed with probably invalidation request in the parallel. Okay, and these are some results from also last year. But this is only for the administrative routes, because as I said, the system was established in 2021, and the civil routes will usually take like 2 or 3 years. So for now, we don't have enough data for the court side. Routes, you could see that like about 30% of the case were found infringed, and another 20 found not infringed, and about another 30 was withdrawn, probably due to some issues like settlement or some negative expectation of the results or something. And there are another 10% due to other reason of the reject. Okay. And this is my take-home message for today. So with the establishment of the patent linkage system, I think it would influence the strategy of the cross-border pharma companies, especially their strategy in China, because for the patent listing system to work, the patent linkage system to work, you have to file the new drug application in China. Once it's got approved, then you can list the patents on the platform, right? So if you don't apply for the market approval in China, then the generic drug of the brand, the generic drug which might infringe our patent could just go ahead with their market approval application being reviewed, right? And then there is another thing called patent term extension, PTE. It will also heavily relied on the timing of the filing of the new drug application in China. Okay, so that'll be for today. I'll stop here. And if you have any questions or suggestions or case-related things, here is my email box. Okay.
Thank you, Shirley, for this informative and analytical overview on the patent linkage system that guide us through, step by step from the very beginning to the end, as well as the comparative viewed on the civil action versus the administrative route of enforcement. Now we go into the third speaker. Let me introduce the third speaker for this panel, Mr. Andy Yu. Andy is a senior associate at DCONT, Hong Kong, specialized in IP/IT and data compliance matters. He is a dual qualified solicitor in Hong Kong as well as England and Wales. He has also just passed the PR China's Greater Bay Area Lawyer Assessment. And he has hands-on experience in assisting multinational clients in their cross-border data transfer and large-scale data compliance remediation projects in China and Hong Kong. And he also completes a 6-month secondment at a legal department of a semi-governmental organization in Hong Kong, where he gained valuable insights from working directly with different business stakeholders in the contract review process. Today, Andy is going to share with us the cross-border IP strategy in the digital age. Now I hand it to you, Andy.
Thank you, Kevin. Thanks a lot. And thank you again to AIPPI and the organizers, Debbie and Sam, for this speaking opportunity again. And it was great to also listen to Shirley and Arios for their sharing just now. So in this last session, I'm going to talk about how we as lawyers can add values when business teams come to you for asking for legal support on IP commercialization in this digital age. And I have selected 2 common business use cases as our focus of discussion today. And they are co-branding and joint marketing campaigns, as well as a loyalty rewards program. So our focus today is to discuss the opportunities from a business perspective and also the legal risk and pitfalls arising from these initiatives. So first of all, in terms of co-branding and joint marketing campaigns, obviously from a business perspective, the rationale of having such campaign is to allow the different partners and entities to leverage their brand reputation to increase their brand exposure and also to ultimately to facilitate business growth. And they can also conduct marketing and promotional activities in a very cost-effective manners by pooling resources together. So as an example, say hypothetically, say an European food manufacturer wishes to target the European sector of customers in Asia, they may consider launching new co-branded products supplied by this food manufacturer together with an Asian distributor, say a supermarket chain. And from a legal perspective, there are 2 key elements involved. Essentially, obviously, it involves an IP licensing arrangement, especially involving trademarks. But the difference in a co-branding agreement is that from a traditional license agreement is that a co-branding agreement is essentially involves 2-way licensing. And it may also depends on the business arrangement, covers elements such as distribution, with one party being the supplier and the other being the distributor. So another common business use case is loyalty and also called reward programs these days, especially involving the use of customers' data. So from a business perspective, it can obviously improve customer retention and to aim to build long-term relationship with your target audience. It can also allow different business sectors to expand their reach to other industry and enhance the overall customer's experience. On the other hand, because of the use of data, it can also enable different parties to better understand customers' behavior and to provide more personalized experience to their customers. So as from a legal perspective, the terms and conditions between the say a 2 different parties, say as a property developer being the host of a loyalty program and their other business partners is governed mainly by a collaboration agreement. That's something that we so-called a collaboration agreement. And apart from cross-licensing of IP rights that we just mentioned, one key element involved in such arrangement is to provide for the terms and conditions for data processing and sharing. So I'm sure that you guys must have come across these two use cases in your daily life. But putting on our lawyer's hat, we also understand that opportunities always come together with risks, especially legal risks. So here are some 3 areas of focus that we will talk about today, and how we are going to mitigate such risks, in our contract review. So let's start with commercial terms and arrangements. So you may be wondering that these are primarily issues to be considered by business teams. But from my experience, there are usually 2 reasons that I always wanted to first review and go through some key commercial terms with the business teams when they ask for legal support. First of all, this is very often the area that could easily go wrong when certain business ideas or arrangements are put into legal jargon, and it's really important for you to clarify and to provide certainty in terms of what has been put into the contract. And secondly, before getting into more complex legal issues, this is usually how I think we can establish rapport with the business team when we focus on certain business issues of their concern. So taking the example of, say the scope of IP license, obviously this is something that we as IP lawyer are very familiar with. But one common pitfall that some other people may not be aware of is that IP rights is always governed by territorial by nature. So it is really crucial for for the business side or team members to understand what jurisdiction they intend to cover. And next step, they will have to also check if the proposed license scope overlap with other existing licenses in respect of the relevant jurisdictions that they wanted to cover. For example, if you have an existing, exclusive licensee in China, then it may not be possible for you to enter into a new co-branding arrangement with another business partner in the same jurisdiction. And there are also, you may be aware that it is a really common way in the marketing sector involving the use of e-commerce stores and social media accounts to extend their exposure. And it is really important for you to check with business team if their new initiatives are going to involve online channels. So you may be aware that it is a rather common practice for a licensee in a e-commerce context asking for issuance of authorization letter to say satisfied certain requirements by the e-commerce platforms. And from the licensor, from the brand owner's point of view, it is quite risky for you to issue a letter without having in place a side agreement or a proper master license agreement setting out the relevant terms and conditions to manage the possible risk. And the key issues that we may usually consider include, say, who has the right to manage and access certain, online accounts upon creation, and what is the duration of the authorization? Does the brand owners prefer to, impose a shorter authorization period with, new partners compared to long-term business partners? Are you going to give the rights to the licensee to sub-license other parties to manage the accounts and also use your mark? And talking about when things go south, do you have any exit arrangements in place? Does the business partner have the contractual obligations to say, for example, terminate or transfer the online account or store to at the direction of the licensor? And last but not least, do you want to, does the business team wants to, impose some contractual remedies in case, there are breach on the side of the licensee? So there are also some other, key issues to consider on the commercial side. Scope of marketing activities. So taking an example of, say, if you have an existing celebrity and engaged as the brand ambassador, if the existing contract does not cover the endorsement of another brand, then this should be factored in and excluded when you are reviewing the new co-branding arrangement so as to avoid any confusion. And payment terms, very, very important terms, because in the context of a co-branding arrangement, like I just mentioned, it is a two-way licensing relationship. And the parties may wish to consider from the tax and accounting perspective whether they need to document the two-way payable royalties into the license agreement in order to satisfy the relevant requirements. Cost, which is another area which could easily be in dispute. because in terms of in a co-branding arrangement, I would later mention, there will be potential joint IP enforcement efforts, and there will also be joint marketing efforts. So who will be sharing the cost? And in case you have conducted some successful IP enforcement actions and recovered some compensation, who is going to who is entitled to the compensation received? And last but not least, protection of brand image and reputation, which is most importance, because in a co-branding arrangement, the parties and the business teams may be concerned that their own trademark, especially their house mark, may be diluted because of the arrangement. So they may consider having in place certain brand usage guidelines. And they may also impose some damage control so as to provide some special conditions triggering the allowing the non-defaulting party to terminate the contract when things go south. So next, we are going to move on to talk about some IP issues. So in the context of a co-branding project, IP ownership is always a very tricky question, because logically, both parties may wish to ask for joint ownership of any new IP developed, such as the new co-branded trademark. It is possible to set up a new entity, say a joint venture, to own and co-manage the new IP. But you can also imagine that this could be very costly and may not be justified from a business point of view. And it really depends on the deal size. Another issue with joint ownership is that there could be potential deadlock in case of termination or any dispute. So who is going to own the IP after the agreement has been terminated? And depending on, like I just mentioned, depending on the deal size, the parties may, instead of having joint IP ownership, they may consider other alternatives to protect each other's legal interests, such as imposing a contractual obligation to prohibit each other from registering the co-branded trademark. In terms of enforcement action, it would also depend on the context of the cooperation. For example, it may make more sense for the consuming-facing party to, in a co-branding project, to be mainly responsible for taking enforcement action because they may be more aware of what's going on in the market. But the other party may also wish to consider if they want to, retain any rights or any say in the decision-making process in terms of whether or not to take enforcement action. So apart from traditional IP rights, another factor that we have to consider is the rights to use data, especially in the context of a loyalty program. This is very often because, like I just mentioned, the parties in a loyalty program, the host of the program, and also the business partner, they are very likely going to share personal data with each other. And they could also potentially be conducting analysis to understand their target audience behavior, and which generally will create some new data or so-called derived data. So if the team wishes to use or even own the rights to exploit such new or derived data, we have to make sure that the relevant data processing or sharing clauses or addendum have duly reflected such arrangements. So last but not least, in terms of indemnities and warranties, I just wanted to quickly bring out that traditionally we have been focusing when in our contract review, we have been focusing a lot on IP, especially as IP lawyers. We will focus a lot on IP non-infringement issues in terms of indemnities and warranties. But it is getting, from my observation, it is getting more and more common to also, take on the issue of whether the indemnities and the warranties, the scope should cover data or cybersecurity related liabilities, especially in data-heavy projects. This is because, apart from a contractual risk, you're clearly aware that non-compliant use of data, especially personal data, will also face potential investigation and penalties from the regulators, which we will actually talk about in a minute. So moving on to the last subtopic that I'm going to talk about, which relates to potential regulatory and compliance issues. So I will be focusing on data-related regulatory or compliance issues, especially given that in the context of loyalty program or even in a co-branding program that involves sharing of data, they are usually very, data heavy initiatives. So you may be aware that, cross-border data transfer has been one of the hottest topic in this era, especially in these few years, with different countries bringing in their new laws governing the data flow involving different jurisdictions. And it is really important to take into consideration that in a project where the data flow involves data transfer from mainland China to other jurisdiction. So as a brief introduction, the PRC Personal Information Protection Law has come into force in I think 3 years ago, back in 2021. So since then, the export of data has been subject to heavy regulation. And Chinese parties may wish to who wish to export data are actually required. One of the requirements for them to export data outside China is to conduct and to satisfactorily pass one of the regulatory filings in order to stay compliant for their data transfer activities. And here on the slide, there are 3 transfer tools that you may have already come across before. First of all, is to pass an official security assessment with the regulator in China called CAC. A less stringent option is to file a standard contractual recorder with the CAC. And the last option, which is less common because there are still uncertainties involved in how to adopt this transfer tool. In view of the limited time, I'm not going to go into details today about what these transfer tools are about, but I just wanted to, in this context, highlight the fact that, in March earlier this year, the CAC has issued some new regulations, actually relaxing the requirements on the regulation of outbound data transfer activities. And they are essentially granting 2 quite important exemptions, especially in our current context, which is the first exemption is so-called the contract exemption. So if the cross-border transfer of data is deemed necessary for the execution or performance of a contract, say a contract for the purchase of goods, then the regulatory findings are not at all required for such a transfer. So this is a really important exemptions to people who are actually transferring data from China to other jurisdictions. And another separate standalone exemption is that if the volume of personal data transfer does not exceed 100,000 data subjects within a certain time frame, then such transfer is also exempted. So these are also very important because previously the threshold is really low, and in any case, before the exemption has been issued, a lot of entities, especially Chinese entities who wish to transfer data outside China, are obliged to conduct their regulatory filings, which is a bit troublesome and costly from a business perspective. So apart from cross-border data transfer, there are also some other data compliance obligations that we have to be aware of, especially involving data transfer and also processing of data in your new initiatives. So first of all, one of the key steps to take before collecting and processing your customers' data is to notify them, inform them of your rules of processing, how you're processing their data and who are the sub-processor of your data. And you have to obtain the consent, relevant consent. In some cases, under the PIPL, so far in China is concerned, a more stringent consent requirement is may be required in certain circumstances. Say, for example, if you want to process sensitive personal data, you are supposed to obtain a separate consent. So you can't really bundle the consent in order to justify your processing activity. So in the context of a loyalty program, it generally makes sense for the party acting as the say the first touch point with the customer to fulfill such obligations, because they are consumer facing, and it makes sense for the users to give consent to the party that they are dealing with. And other pain points to be aware of includes, like I just mentioned, processing of sensitive personal data, such as biometrics data, usually require more stringent compliance obligations. And you really have to justify, you satisfy the regulators in case you've got inquiries from them, why do you have the need to, process and collect sensitive personal data? in, say, for example, in a general consumer context. And another legal risk that you may have to warn or be aware of is that you may the company may have to bear joint and several liability if they are being held as a joint data users or controllers in a loyalty program or joint marketing program. And you may also have to be aware that you have the obligations to respond to and process data subjects request. So here are some key takeaways that I would like to share. I would like to highlight that the issues that I talk about today are just some of the issues, but not all areas of concern in the contract review process involving commercialization of IP. But it is, I think, from my experience, I think it is always a good practice to first understand the risk appetite and also the needs, the business need, and to evaluate on the legal side, from a legal perspective, how you're going to structure and handle a deal on a case-by-case basis. And it is also crucial to understand the bargaining power and the dynamics between the contracting parties in the new transaction in order to better facilitate the negotiations and to close the deal ultimately as the ultimate goal. So this is my sharing. If you guys have any questions about the topic that I just raised, feel free to reach out and we can connect on LinkedIn when we can talk about more later on. Yep. So if any questions, please feel free to raise, and I will just pass back the stage to Kevin. Thank you.
Thank you, Andy. Thank you. Personally, it's reviewing your presentation and material, come up with one question. When you go back to the you're talking about the regulatory filing, the license from the transfer of personal data from mainland China outbound to foreign country. If that application has been rejected, then and also the transfer does not fall into any one of the exemptions, what would be the possible consequences and impact to the transferee and the recipient of the data?
Well, Kevin, I think this is a really good question because we are also actually working on different projects, and we have been advising different overseas recipients about the possible implication. So I think first thing is that the primary obligation to comply with the regulatory filing obligations under the PIPL rests on the Chinese party to comply with the obligations. But if say the CAC or the other regulators are going to reject the application, or they see that the certain transfer activities does not fall within the exemptions, they can actually order to prohibit or restrict the data export. And while the primary obligations are on the Chinese party, and therefore the Chinese party will be the first party being subject to possible penalties or etc., it will definitely affect the business need and the operation of the overseas recipients at the receiving end, because you can't receive data at all. So I think it's important for it really depends on the context and also on the arrangement of the business cooperation. But I think it is important for the parties to understand their legal position and their business need when they want to, when they are trying to, formulate their overall strategies in terms of how to, facilitate the data flow involving, cross-border parties.
Thank you, Andy. I don't see any question at the chat box presented. So I would like to also ask a question for Shirley about the patent linkage. Well,
Yes.
more a broader picture. How do you think the linkage system will influence overall for the innovator drug company, as well as a generic drug company?
Yeah, I think that that the answer to that question will have to be seen in a more long time, because the system is very newly established in China. But from my perspective as a litigator, I think first of all, for the innovator, the brand drug company, the clear benefit is they could stop the generic drug as early as before the generic drug could get the approval, could hit the market. And that's the huge benefit for the brand drug company in a very long time. That's what they want. And also the collection of the evidence become easier, because during the infringement suit triggered by the patent linkage, the patent holder could just file an application to the drug reviewing office for getting the data, the detailed technical information of the generic drugs. So that will make the comparison between the drug and the patent claims become easier. And for the generic company, I think one benefit is they could settle the dispute between patent holder before they hit the market. So that will give them a higher certainty of the marketing of the drug. And that will make the price of the drug and also the accessibility of the generic drug become more stable to the the patients as well. So generally, I think it's a very beneficial system. But then there might be some shortcomings. But I think it's we have to wait and we'll see in the future.
Okay, thank you for your answers. Okay, I'm sorry, we were running a little bit behind time. So before concluding this session, I will again to express my appreciation to all the three panel members for sharing their valuable insights and practice tips, and also audience who's staying with us, as well as Jae Won Yoon, one of the member of the AIPPI Young Committee member who's standing by for helping. Again, if you have any more question about the topics in this session, please free to ask to reach out to us. And I'll look forward to more discussion on these good topics. Now I hand it over to Debbie. Thank you.
Yeah, thank you, Kevin. Thank you so much all for such a wonderful, insightful session. So I'll be doing announcements, but shortly after that, we will like to invite you all to turn on your cameras so we can take a group photo of this Summit Satellite session. So please stay for a minute for the photo. So as for the announcement, we would like to remind you all to provide us with your valuable feedback. We will be sending you an email after the session with a feedback form. So please do fill that in to help us understand your preference and better plan our future young member events. We would also like to encourage you all to attend the next satellite sessions for our European session, which will be held at 10:30 a.m. CEST. Along with America's session at 6 p.m. CEST. These sessions will continue to feature very exciting and interesting regional specific topics. So do sign up for them if you have not yet. Lastly, I want to remind all of you that the AIPPI World Congress will take place this year in October in Hangzhou. Early bird registration will end on the 9th of July. So remember to take advantage of this discounted rate and register while it's available. And we also look forward to see you all in person then. Do look out for our Young AIPPI members events during that time at the Congress. We'll be hosting the Young AIPPI Members Forum and other gathering events. So now I want to invite all of you to take a group photo, to turn on your cameras, and the AIPPI events team will help us with that. So Cinzia, our team, please let us know when you're ready.
You're ready?
Thank you. So on the count of 1, 2, 3, cheese. Let's smile.
Thank you.
Thank you. Thank you all. We will be
Samantha,
posting
I think
this.
Sorry,
Yes.
just one quick thing was on our WhatsApp group.
Yes.
Yeah, so if those of you
We'll
who
send out
have
the
yet
link
to
now.
join our WhatsApp group, please do feel free to use the link in the chat to join the WhatsApp group and stay connected with the young members of AIPPI. Yeah, that's it.
Yep, exactly. Thank you, Debbie. So the WhatsApp link has just been sent out on the chat group. So please feel free to join if you have not. That is specifically for our young AIPPI members. So to keep you in the loop. So once again, on behalf of the Young AIPPI Members Advisory Committee, we would like to extend our deepest gratitude to all of you for attending, speaking, and also to the AIPPI Bureau, the General Secretary and the events team for your wonderful support. So thank you all again, and we'll see you all in the next sessions, if not in person in Hangzhou. Thank you.